Good morning, everyone, and hello from Washington, D.C. I'd like to also thank our host for today's event for the invitation to join you all today. My name is Amanda Strayer, and I'm an attorney with Human Rights First, which is a research and advocacy non-governmental organization which is focused on ensuring that the U.S. government upholds its human rights obligations and that the protection of human rights is at the heart of U.S. foreign policy. So in my role with Human Rights First, I help coordinate a coalition of hundreds of human rights and anti-corruption NGOs around the world who are interested in advocating for the use of sanctions tools like the Global Magnitsky Act to hold perpetrators accountable. So together we work with NGOs to assist them, as Bill was mentioning, in developing comprehensive, credible, evidence-based case files documenting alleged crimes by human rights abusers and corrupt actors, and then work to submit these files to the US government and to other foreign governments with similar sanctions programs, as has been discussed. So we provide training and advice to partner organizations to help them put forward the most credible, corroborated case files to the US government. And through our close working relationships with the US Department of the Treasury and state, we've developed a template that helps NGOs provide the information the US government needs to consider taking action on sanctions recommendations. And we'd be very happy, of course, to work with any of you who may be considering filing a case under the US Global Magnitsky program. So I'd like to spend a little bit of my time today providing a bit of a background on the US Global Magnitsky Sanctions program, how it works, who can be sanctioned, and what NGOs and lawyers should be considering when they're thinking of who to recommend for sanctions. So the Global Magnitsky Human Rights Accountability Act was passed in December 2016, and the executive order that implements that act, Executive Order 13818, was issued the following year. And together, the act and this executive order provide the legal framework for the US Global Magnitsky Sanctions Program. In the 4 years since these laws have come into effect, the US government has sanctioned 246 individuals spanning 34 countries, which is very heartening for us to see that this tool is being used and being used regularly by the US government. And these sanctions result not only in the public announcement of the sanctions, which has the name and shame factor to it, but more concretely results in visa restrictions and asset freezes for any assets that the perpetrators might have in the United States. So what these sanctions cover, they're meant to address, quote, serious human rights abuses and corruption. On the human rights side, generally these sanctions are reserved for acts of physical violence against victims, things such as extrajudicial killings, torture, cruel and human degrading treatment and punishment, rape and sexual violence, enforced disappearances, in cases of prolonged arbitrary arrest and detention. Those are generally where we see these sanctions programs being most frequently used. And many of the cases also involve a pattern of ongoing serious human rights abuses indicative of widespread or systematic abuses. So for example, the US government recently sanctioned several top-ranking Chinese officials and entities for their involvement in human rights violations amounting to genocide against the Uyghurs in Xinjiang and other minorities. But this isn't always the case, as has been mentioned earlier too, in the case of Jamal Khashoggi. Following his murder, the US government sanctioned 17 Saudi Arabian officials who were involved in perpetrating this killing. And so there, it's just the case of one killing wasn't sufficient to trigger a sanctions designation. And we'll see, pending today's announcement from the United States, what additional actions may perhaps follow from that. Unfortunately, however, the law is not meant to address every type of human rights abuse or violation. So for example, abuses that violate the rights to freedom of expression, assembly, or association are not covered specifically by the law, nor are acts of religious persecution, unless there's an act of overt violence as part of that persecution or part of the infringement of these other rights. Additionally, we've seen the US government recognize that there are strong links between human rights abuses and corruption, and numerous sanctions designations have been made on the basis of corruption, where the sanctioned individuals were also involved in human rights abuses. So a couple examples that we've seen in Uganda, there were 2 judges who were sanctioned for taking bribes as part of an adoption scam, whereby children were taken from their parents on the false pretense and promise of special education opportunities in the United States. But those children were then offered for adoption to US families. So the judges were sanctioned for their corrupt act of taking bribes, but obviously they were involved in human rights abuses against the children in these families. Likewise, in the Democratic Republic of the Congo, we've seen businessman Dan Gertler was sanctioned for his corrupt mining and oil deals with then President Joseph Kabila, which deprived the DRC of $1.36 billion just between 2010 and 2012 alone. And that obviously had a huge impact on the country and the ability to protect human rights in that country. I think that amount was could have funded half of the country's health budget just during that time period. But again, Gertler was sanctioned on the basis of involvement in corruption, though his actions clearly had human rights repercussions as well. So in looking, considering using Global Magnitsky to address human rights abuses, we encourage folks to also be mindful and consider of whether there might also be corruption at play in the issues that you're looking at and that you can raise with the US government. Once you've identified specific sanctionable abuses, obviously the next consideration is who can be sanctioned under the law and held accountable for these abuses. And under GLOMAG, there's several different grounds for culpability for human rights abuse. There's the very standard culpability of someone being responsible for, complicit in, or directly or indirectly engaged in the abuse. But additionally, the GLOMAG has a status-based designation. So a person can be sanctioned solely because they are a leader of an entity or organization whose members are perpetrating human rights abuses, even if that person themselves is not directly involved in the human rights abuses. So for example, a few months ago, the US sanctioned the former Deputy Minister of the Interior in Yemen, a man by the name of Abdul Hakim al-Kawani, who was responsible for detention facilities and security forces that were arresting, detaining, torturing, and raping women who opposed the Houthis under the pretense of a policy to address prostitution and organized crime. So while al-Kawani himself did not directly perpetrate these crimes and abuses, the Ministry of the Interior had ultimate authority over the individuals who were perpetrating the abuses. And because al-Kawani was a leader, a high-level leader within the Ministry of the Interior, the US government was able to target him for sanctions. And finally, the final ground for culpability would be any individuals who are providing material assistance, sponsoring, providing support for human rights abuses. These are all grounds for sanctions, as well as attempting to commit any of the sanctionable crimes. And on this note, I'll just say it's important to remember too that both natural and legal persons, so entities, organizations, et cetera, can be sanctioned under the US law. It also applies to both state and non-state actors. So we've seen this tool used in Libya against the Khaniyat militia and its leader for murdering civilians, torture, and forced disappearance and displacement. So you're not solely limited to government actors. But one question we do often hear is how senior are the officials who are sanctioned by the US government, and can the leader of a country be sanctioned? Generally, we've seen the US government's been very willing to sanction individuals who are quite senior in government. For example, I've mentioned several of the top leaders in Xinjiang, as well as top leaders in the Burmese military have been sanctioned for their role in the genocide against the Rohingya. However, it's very, very unlikely the US would ever sanction a sitting head of state, but they would potentially consider it for a former head of state. So we saw a couple years ago, the former president of the Gambia, Yahya Jammeh, was sanctioned for decades of human rights abuses, including ordering the killings of journalists and opposition members and a local religious leader, among others. And these sanctions against Jammeh came less than a year after he left power in 2017. So, to the extent that you're looking at heads of state, very unlikely it would happen, but potentially after they've left office, they could be targeted. I think the final component of the GLOMAG that's really important to keep in mind too is in the US, it is a discretionary tool. It's not a mandatory measure for the US to take. The US considers global Magnitsky sanctions as a way to encourage behavior change and not as a punitive tool. So they're looking to use it in very recent cases and one where there's a strong national interest for the US to act. So part of the role of advocates and lawyers working to submit these case files is to help spell out to the US government exactly why designating these particular perpetrators for these particular abuses is in the US national interest. So these arguments can take many different forms. For example, does the perpetrator have ties to the United States, either through assets that they hold here, frequent travel to the United States, family that are here, et cetera? Identifying any information along these lines can help demonstrate that sanctioning this particular individual is going to have a real impact on them, which is something the US government is keen to use this tool in ways that are impactful. Other things that you might consider are the foreign policy reasons why sanctions might be the right tool in this case. So for example, could the sanctions send a targeted message to a government or to a military unit? Could they isolate an individual spoiler? Could they help reduce future abuses within a particular unit or deter other actors from committing similar abuses? Unfortunately, as we know, there's all too many incidents of human rights abuses around the world today, and it's not possible for the US to sanction every single bad actor out there. But by building a strong argument as to why it's important for the United States to take a stand, why it's in their national interest to take a stand to target a specific person, will go a long way towards strengthening your case. And so I'll kind of wrap up here. I mean, as you know, we're still in a period of transition in the United States as the new Biden administration begins to implement its own foreign policy priorities going forward. And we haven't seen any global Magnitsky designations under the new administration yet, but we do expect it will continue to be a key feature of US foreign policy in the years ahead. The law has consistently enjoyed broad bipartisan support here in the US, and we know that the Biden administration does view targeted sanctions as an important part of their foreign policy toolbox, and one they're seeking to use in more effective and multilateral ways with foreign partners like the UK and the EU and Canada. Then the Treasury and State Department are eager to continue working with civil society to receive information and recommendations that can lead to sanctions. We've seen a few early indications that the Biden administration may also consider using the tool in new ways, such as to respond to human rights abuses that have been largely overlooked in the past, such as targeted violence against LGBTQ persons. We're also hopeful to see more sanctions that address issues that have also been overlooked to date, such as gender-based violence, child victims, those who are fighting for climate justice and under attack. And here, civil society, I think, has an important role to play to bring forward strong case files for sanctions that can help the US government identify the areas where sanctions can make a real difference for the most marginalized and vulnerable victims of human rights abuses. So my colleagues and I at Human Rights First, we'd be happy to work with you and your organizations to provide additional training or to discuss any cases you might be considering filing and offer guidance and advice through that process. And so with that, I'll conclude and thank you again for the opportunity to speak with you today and look forward to any questions.